PC 518 Extortion in San Francisco, where the line falls. San Francisco is home to major financial institutions, tech companies, nonprofits, and media organizations. Because of this, disputes often involve high stakes, and sometimes those disputes lead to accusations of extortion. Consider a few common situations. A lawyer sends a demand letter threatening to report regulatory violations unless a settlement is paid. A former employee threatens to expose misconduct unless they receive compensation. A business dispute escalates, and one side threatens public exposure unless money changes hands. In each of these cases, the key legal question is the same. Was this a legitimate demand or criminal extortion? That line is not always clear. In fact, in San Francisco's business environment, it is often heavily contested. What counts as extortion under California law? Under California Penal Code 518, extortion occurs when someone obtains money, property, or an official act through the wrongful use of force or fear. The most important word here is wrongful. Not every threat is illegal. The law recognizes that people can make strong demands, especially in legal or business disputes, without committing a crime. Common types of extortion threats. California law generally recognizes three main types of threats that may qualify as extortion. 1. Threats to harm a person or property. 2. Threats to accuse someone of a crime. 3. Threats to expose a secret that could harm someone's reputation or business. In San Francisco, the second and third categories are the most common, especially in business, employment, and online disputes. The legitimate claim defense. One of the most important protections in extortion cases is the legitimate claim defense. California courts have made it clear if someone makes a demand based on a good faith belief in a real legal right, it is not extortion, even if the demand includes a threat. For example, threatening to file a lawsuit over unpaid wages, warning that regulatory violations will be reported, seeking compensation tied to a real dispute. These are not automatically criminal. The line is crossed when there is no real legal basis for the demand. The threat is purely coercive. The demand is unrelated to any legitimate claim. In San Francisco, where disputes often involve complex legal and financial issues, this distinction becomes critical. Legal elements of extortion. To prove extortion, prosecutors must show a threat was made, harm, accusation, or exposure. The threat was intended to obtain money, property, or action. The threat was communicated to the victim. The victim complied. For completed extortion, if the victim did not comply, the case may be charged as attempted extortion under PC 524. Penalties. Extortion under PC 518 is always a felony, carrying 2, 3, or 4 years in state prison. Attempted extortion, PC 524, can be charged as either a misdemeanor or felony. Additionally, written threats such as emails or texts may be charged separately under PC 523, which is also a felony. Why extortion cases are common in San Francisco? San Francisco's economy creates unique situations where extortion allegations arise frequently. 1. Financial and investment disputes. Conflicts between investors, advisors, and clients can escalate into threats involving lawsuits or regulatory complaints. 2. Tech industry and DAS. Employees with access to sensitive data may threaten disclosure unless compensated. These cases often sit at the intersection of whistleblower rights and extortion law. 3. Nonprofit and public advocacy. Advocates or insiders may threaten to expose wrongdoing. These cases often involve First Amendment protections and public interest arguments. 4. Online threats and sextortion. Digital communication has led to a rise in sextortion cases, threats to release private images unless money or more content is provided. These cases are aggressively prosecuted. How investigations are built. In San Francisco, extortion cases are usually built on digital evidence, emails, text messages, recorded calls. Law enforcement often collects the full communication history and may even guide the alleged victim to respond in a controlled way to gather more evidence. Another key factor is motive. Many extortion claims arise from business disputes where both sides have financial interests. In some cases, criminal accusations are used as leverage in civil conflicts. Defense strategies that matter. Successfully defending an extortion case often comes down to context and intent. 1. Legitimate claim defense. Showing that the demand was based on a real dispute or legal right can defeat the case entirely. 2. First Amendment protection. Certain communications like demand letters or warnings about public exposure may be protected speech. 3. Lack of intent. Angry or emotional statements are not automatically extortion. The prosecution must prove a clear intent to obtain something through wrongful threats. 4. Full context of communication. Messages are often taken out of context. Reviewing the entire conversation can change how a statement is interpreted. What to do if you're accused of extortion. If you are facing an extortion allegation in San Francisco, your actions early on are critical. Stop all communication with the alleged victim. Preserve all messages and records. Document your legal position, contracts, disputes, evidence. Do not speak to investigators without a lawyer. Many cases can be influenced or even prevented before charges are filed with the right legal strategy. Why these cases are so complex. Extortion law sits at the intersection of criminal law, civil disputes, free speech rights. In a city like San Francisco, where legal, financial, and tech issues overlap, the difference between a lawful demand and a criminal threat is rarely obvious. That's why these cases require careful analysis, not just of what was said, but why it was said and what rights were being asserted. Final thoughts. Extortion charges are serious, but they are also highly fact-dependent. What may look like a threat on the surface could actually be a lawful attempt to resolve a dispute. Understanding where the legal line falls and how to defend your position can make all the difference. If you found this helpful and want to better understand your rights or legal risks, don't wait until a situation escalates. Getting clear guidance early can protect you from serious consequences. If you're dealing with a dispute that could cross into extortion territory, or you've already been accused, reach out to a qualified defense attorney as soon as possible. Need help or have questions? Contact a legal professional today and take control of your situation before it turns into a criminal case.